Duffany, who's approaching the podium as we speak. Mr. Duffany, please introduce yourself to the court. Thank you, Judge. Today's the date and time set for probable cause conference. I was just appointed on this matter yesterday afternoon, so we are asking for a brief adjournment for discovery and for plea negotiations.
Right out of the gate, this courtroom already feels unstable. The defense attorney is basically walking into the fight mid-round, telling Judge Simpson he was only appointed yesterday afternoon and needs time to catch up. That alone tells you this case is not exactly organized behind the scenes. But then things immediately shift from routine scheduling into something way more serious: bond compliance and drug testing. And that's where courtroom reality starts hitting hard. A lot of defendants think missing a test because they didn't have the money sounds understandable. Judges? Not always. Especially when bond conditions are involved. The court doesn't hear inconvenience, it hears non-compliance. And Judge Simpson is already sounding skeptical. The moment he asks, is he going to test clean, the tone changes completely. That's no longer paperwork talk, that's credibility talk. And in court, once credibility starts slipping, everything gets harder. Bond, negotiations, sentencing, all of it. Let me ask you this: if someone can't afford the test required by the court, should that count as a violation? Or should there be more flexibility built into the system?
At this time, there's also a bond violation, or
There is.
Yes, Judge. So I spoke to Mr. Duffany. He went to community corrections yesterday at 4:20 p.m., but he did not have the money to test, so he was unable to. We did discuss today. He's going to go immediately to community corrections after this. I do have an email from community corrections to confirm that he was there.
Is he going to test clean?
I believe so, Judge. Yes. He's on what?
Are you going to test clean?
I'm on Suboxone. I'm prescribed Suboxone.
You're prescribed it? I'll pass it. He needs to get over there and test and then come back.
So thank you, Judge.
I'm not doing that anymore. Takes a lot. Just go on. Court recalls the case People versus Justin Duffany. Yeah.
Good afternoon again, Your Honor. Good morning, Chief Assistant Prosecutor appearing on behalf of the people.
Can I put it back on the record with Mr. Duffany? Justin, please state your name for the record.
Justin Duffany.
I've seen the results, Judge, and I have gone over them with Mr. Duffany.
He doesn't have a prescription for cocaine, Mr. Allen.
I would assume no. Gonna be all right. Gonna be all right.
All right. I'm going to adjourn the probable cause conference to August 14th, 2025, 9 a.m. His bond at this time, given the violation, his bond is revoked. Defendant's remand.
Thank you, Judge.
And there it is. The hammer drops fast. Judge Simpson didn't spend 10 minutes debating this. He saw the violation, looked at the failed compliance issue, reviewed the situation surrounding the testing requirement, and immediately revoked bond. That is a brutal reminder of how fragile pretrial freedom actually is. One violation, even before the main case is resolved, can completely change a defendant's situation overnight. Now notice something important here. The court isn't deciding guilt or innocence yet. This is strictly about whether the defendant followed the conditions required to stay out of custody. That distinction matters. A lot of viewers confuse bond violations with convictions, but legally they are very different. Still, from a practical standpoint, getting your bond revoked is devastating because now the defense loses leverage, loses flexibility, and suddenly every future court appearance happens from custody instead of freedom. And emotionally, you can already feel the pressure building in this courtroom. The defense is trying to stabilize things while Judge Simpson is making it crystal clear. If the court gives you conditions, they expect strict compliance, not explanations afterward.
Good morning, Your Honor. Assistant Public Defender Constable Bass on behalf of Mr. Brandon Bowman, who's present to my right. Can you state your full name for the record, please?
Brandon Charles Bowman.
Now, today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
If I could address bond, Your Honor.
Are you going to address the additional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right. You want it set for exam
Yes, Your Honor.
and you have the discovery.
To my knowledge, yes.
Would people have their witnesses available at 12?
We'll do our best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Fresh Hour. As to bond.
Your Honor, I believe the defendant is in custody on a no contact order bond violation originally. After he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report since being put back in for violating the law.
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that,
Your Honor, I haven't seen anything about these calls. My client is saying that he's.
I have not made one phone call.
Your Honor, he's going to be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull up my internet and not.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out.
This is one of those moments where Judge Simpson slows everything down and starts dissecting the details instead of reacting emotionally. And honestly, that matters because prosecutors are raising serious allegations here. 21 attempted contacts with the victim after a no-contact order violation. That sounds terrible on paper, but the judge immediately focuses on evidence and attribution. Were the calls actually made from the defendant's PIN? Because in jail systems, PIN usage matters. It's essentially digital identification. Without confirming that link, the court risks punishing someone based on assumption instead of proof. And you can feel the tension between protecting victims and protecting due process at the same time. That balancing act is difficult in every courtroom. The defense is denying the calls entirely. The prosecution is pushing the violation narrative aggressively, and Judge Simpson is trying to separate verified facts from courtroom momentum. That's actually an important judicial instinct. A lot of viewers only focus on dramatic reactions, but moments like this are what really define a judge, slowing down before making a punitive decision that affects someone's rights and jail conditions.
Well, why don't we do it this way? Mr. Mulvacy, you can talk to the prosecutor's office regarding that. If they did come from, I'm going to, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay. So get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir? All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up real quick.
Oh, you do have it? Hold on.
They're from different pins.
They're from, are any of them his?
No, they're all different pins. There are 2 different pins that are being used, but not close.
And none of the calls were connected?
Correct.
All right. I'm going to deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days.
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing. If
That I would not be sentencing him to the 8 days on it.
Understood.
I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes, I'm going to need one for different.
Okay. Understood, Your Honor. Then we'll keep it as it is.
This exchange is subtle, but legally it carries weight. The defendant was essentially trying to negotiate around the bond violation by admitting responsibility while hoping for credit for the 8 days already served. But Judge Simpson shut that down carefully and strategically. He basically told the defendant, "Don't assume admitting the violation guarantees the outcome you want. That changes the calculation instantly." Suddenly, the defense realizes the admission could hurt more than help. So instead of forcing the issue, they back off and keep things where they are. And honestly, that was probably the safer move. Courtrooms are full of moments where defendants talk themselves into worse outcomes because they think cooperation automatically equals leniency. It doesn't. Judges weigh timing, credibility, history, compliance, and risk all at once. Also notice how calm Judge Simpson stays here. No yelling, no theatrics, just controlled courtroom management. Sometimes that calm tone is actually more intimidating because it signals the judge already understands the consequences and doesn't need to dramatize them. That kind of restraint changes the entire energy of the hearing.
Sorry. Once I check your private screen. Yeah, man, I'm just a figurehead.
Alexander, on behalf of the people, Your Honor.
Covered on behalf of Mr. Amison, who's approaching the podium. Amison, please state your name for the record.
Mario.
So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed. However, we are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
And if I could address feel free, Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before Judge Freshour. Yes, that's the bond.
Your Honor, it's come to my attention that Mr. Amison has called the victim in this case 100 times since his arraignment. So at this point, I would be asking.
What? 100 times?
100 times.
Okay.
So I would be asking that his phone privilege be revoked. It's her listed number in this report as well.
Response?
So, Your Honor, I spoke with Mr. Amison in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge.
My bad. Go ahead.
Technically, it was, Judge, because it was through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond. Or to, I don't know. I got it.
This right here is where defendants get themselves into serious trouble all the time. Misunderstanding no contact orders, or at least claiming they misunderstood them. The defense attorney is trying to clarify the rule in plain English. It does not matter who initiates contact. If there's a no contact order, the burden is on the defendant to avoid communication completely. And you can tell this situation has already spiraled into confusion because the defendant keeps pointing to the victim's actions as justification. But courts usually don't see it that way. Judges expect defendants to follow the order regardless of mixed signals, emotional attachments, or ongoing communication attempts from the other side. That's why these violations become so dangerous. They create messy factual disputes, emotional arguments, and endless "but she contacted me first" explanations that rarely help in court. And honestly, this hearing is turning into a perfect example of how quickly personal relationships collide with legal restrictions. Question for viewers: do you think no contact orders should apply equally, even when both people continue communicating voluntarily? Or should context matter more than strict enforcement?
Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted, but we did explain what it means to have a no contact order in place. And going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me, just talk, man.
What do you want to say?
She came and visited me, man. They let her come to visit me, so it couldn't have been that serious of a non-contact.
So, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and the
domestic violence or nothing. This is fraud case.
we got it. It's my understanding that the complaining witness has reached out to him several times, so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. So that at this point we are.
Let me ask this then. Other than those times where the defendant alleging that the victim has come toward him, are the phone calls his calls out to her?
Your Honor.
Some are from his pin and some are from other pins.
Well, I understand that, Mr. Burdell, there might be a mix-up when she comes there. And
I got one more thing to say, man. You ain't wearing it right, man. Excuse me, can I talk? I know how to talk. You feel me? I got you. She came.
Sure, go ahead.
She came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. She able to visit me if it's a no contact order, and I'm in jail.
That I don't know, and that's why I asked if there were. I'm trying not to take those contacts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that. Then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
Right.
Judge Simpson is cutting directly through the emotional noise now. The defendant is trying to explain context, confusion, visitation rules, and the nature of the relationship, but the judge keeps steering the conversation back to one narrow issue. Did the defendant initiate prohibited contact? That's the legal core of this entire argument, and this is where a lot of defendants accidentally hurt themselves. Instead of giving concise answers, they start arguing fairness, motives, and background details. But judges often interpret that as avoiding accountability. The defendant here clearly feels misunderstood. He's frustrated, talking over the process, insisting the story is incomplete, even minimizing the underlying case by calling it a fraud for $30. But none of that changes the standing court order. And you can see Judge Simpson trying to maintain control without escalating the situation emotionally. That's difficult because once defendants start speaking directly from frustration instead of strategy, hearings can spiral fast. The courtroom dynamic here has completely shifted from procedural scheduling into a credibility battle, and credibility battles rarely end well for defendants already facing compliance issues.
I was under the impression that I wasn't able to have no contact upon my release. They said during bond, we can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir.
Like,
I don't.
Because they telling you half the story, man.
I'm not going to get that information right now. I'm not supposed to have that information right now. Anything else, Mr. Anything else, Mr. Burdell?
No, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making out, either from his own pen or from other pens, because that is not allowed and strictly prohibited. The defendant's phone privileges at this time are revoked. You can make the argument before Judge Freshour to reinstate them after the preliminary examination.
Thank you.
Thank you.
You five, man.
What'd you say?
You five.
Come talk to him, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. I'm gonna pick up the next one. And just... This is on your advice, because I got something to say, but I'm not going to.
What a chaotic sequence of hearings this turned out to be. Across multiple defendants, Judge Simpson kept coming back to the exact same core issue, compliance. Whether it was failed testing requirements, disputed jail calls, no contact violations, or confusion over bond conditions, the court repeatedly showed that pretrial rules are treated very seriously. And the biggest takeaway here is that small decisions outside the courtroom can create massive consequences inside it. We saw bond revoked, phone privileges revoked, credibility questioned, and repeated reminders that judges are not only evaluating charges, they're evaluating behavior while the case is pending. Judge Simpson, throughout all of this, stayed focused on procedure, evidence, and enforcement rather than emotional arguments or excuses. That consistency shaped every ruling we saw today. And honestly, this hearing was a perfect example of how quickly courtroom momentum can turn against a defendant once violations start stacking up. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments and don't forget to subscribe for more jaw-dropping courtroom breakdowns.